What about prototypes for your invention? Do you need a prototype? Let's talk about that. So in order to talk about prototypes, I want to bring to your attention a concept that's called reduction to practice. Reduction to practice. So reduction to practice means you're doing something to bring the conception of your invention into the real world. Your invention is conceived in your mind, and you bring that to our three-dimensional reality through what's called reduction to practice. So there's two ways to do that. There's what's called actual reduction to practice and constructive reduction to practice. So actual reduction to practice means you're building a prototype. You're actually building the conceived invention and making sure that it works. You're building it, getting it to work. That would be the equivalent, I would argue, of building a prototype. If you build a prototype and it shows that your invention works, then you've performed what's called actual reduction to practice. Now, the second form of reduction to practice, and both can be done at the same time or they can be done independently, but the other form of reduction to practice is constructive, which means you file a patent application. So instead of actually building the prototype, you have enough information from the conception of the invention in your mind to put information on paper that would teach someone how to make and use your invention. As long as you can provide enough information on paper so that someone could take that information and make and use the invention, then that would be constructive reduction to practice. And the information that you have to put into that patent application has to be enough for not any person to be able to make and use your invention, but a hypothetical person having ordinary skill in the art. So the term that's used is the PHOSITA. So the PHOSITA is an acronym for a person having ordinary skill in the art, the PHOSITA. That PHOSITA might have different skill sets. For example, if your application is related to some type of machinery, then that PHOSITA might have to be an engineer that has a mechanical engineering degree that would know how to make and use your invention. However, it's not necessary that that PHOSITA has to be an engineer. They just need to be a person that has the skill set that's sufficient in order for them to understand your specification and be able to make and use the invention. In some cases, they might have to have a PhD in nuclear physics. In other cases, they might need to be an electronics technician, and in other cases, they might have to be a school teacher. There could be any number of skill sets that PHOSITA would be required to have in order to make and use your invention, but that's a subject for another conversation. The point here is that the reduction to practice, if it's a constructive reduction to practice and you're putting your conceived invention onto paper, you have to disclose enough information for the PHOSITA to be able to make and use it. Now, if you build a prototype, are there advantages? I would argue there are advantages because, first of all, if you have a working prototype, you know that your invention works. There isn't going to be a lot of doubt about whether it works or not, and you're not going to have a lot of doubt about whether you know how to make and use it. And so that speaks to what's called possession of the invention. You're showing that as an inventor, you have possession of the invention. Now, one thing to keep in mind is that patentability can be limited if you disclose the invention publicly to others and a period of time goes by. In fact, in some countries outside the United States, if you disclose your invention, you're no longer able to obtain a patent for that invention. There's an importance to keeping your invention secret until you file your patent application. So if you create the prototype, that might be something that's done behind closed doors, kept secret until you're ready to file the patent application. If you're building the prototype for the purposes of making sure that everything works, that's fine, but you want to keep that a secret until you file your patent application, because if you start talking about it and disclosing it, you might be barring yourself from patentability. And so you don't want to have that issue. You don't want to have that stumbling block stop you from obtaining patent rights later on in your invention. So maintaining secrecy is important, but it is, I think, a good idea to build a prototype. Another reason it could be good to have a prototype is that later on, when you're arguing with the patent examiner over the patentability of your claims, it can sometimes be helpful to have a prototype and actually show the patent examiner the prototype to give them a clearer idea of what the invention is and how it works. So having a prototype can be helpful in a number of circumstances. And of course, if you're trying to go out and market your invention or sell your invention, having a prototype down the road is also going to be helpful for that purpose as well. So it depends on what your business goals are, what your strategy is. and what your purpose is of getting a patent. And if you're not sure whether you should get a patent or not, please see my video that discusses a patent as a business tool linked somewhere over here. So in summary, a prototype is not a necessity for filing a patent application as long as you know how to make and use the invention and can articulate that well enough on paper so that the PHOSITA can make and use the invention. And if you're working with a patent attorney, the patent attorney is going to help you in doing that. If you're working on your own as a pro se inventor, in other words, filing a patent application on your own, it may be a little bit more work. It's not that you can't do it, you can. But if you're working with a patent attorney, the patent attorney should help you to develop that language and develop the specification and drawings. As long as the PHOSITA has enough information to make and use your invention, you're okay. You don't have to have a prototype. Having a prototype has advantages that can be helpful later on down the road, but it's not a necessity to filing a patent application. So if there are any questions on that, let me know. But to answer the question of whether a prototype is needed for filing a patent application, it's not a necessity to have a prototype.